The clear danger is that through this flagrant violation of CI 47 and the darkness of the current proceedings being held in camera behind the walls of a Edu Lodge, my lawyers and I can come to the end of the proceedings. The evidence will show that every one of those allegations in the petitions that were given to me on 27th March is unfounded and untrue. And yet, the committee can dig up some allegation from whatever documents they claim to be having from the president, which they have not shown to me, and purport to enter a recommendation for my removal on that basis. Allow me to say that this is totally unknown in the rule of law in this country. If it was lawful, I would have no reason to alert the nation of the dangers they represent. It is the violations of law that have forced me to bring these matters out in the light of day. The final and fourth reason for this statement is that I have heard on several occasions from loved ones, persons who care, persons who may not know me beyond my public duties, and many who think that since these proceedings seem to be carefully staged to result in my removal as Chief Justice, it would be best if I just retired or resigned rather than subject myself to an ill-motivated process. I have also received threats and veiled threats to the effect that if I fail to resign or retire voluntarily, I will be made to suffer some harm or the other. I've also heard commentaries in the media about how this process was born out of a stated political agenda to remove me and control the judiciary, and that it is a political effort that can only result in an outcome that was decided long before it started. I am confident that in my journey as a lawyer, as a judge, and now as Chief Justice, there is no one person in this country who can look at me in the eye and accuse me of taking a bribe to decide a case. This is the personal treasure of integrity that I live with. So what if these current proceedings are being carefully staged to result in my removal as Chief Justice, even if there's no lawful justification? All I have stated shows that any such action would have been done on the basis of lies and violations of law and due process. As a career judge who has served under 4 presidents, the last petition is from a group called Shining Stars. Searches have shown that no such group is registered in Ghana. Yet, it has petitioned against me, and they claim that during the hearing of the case of Afenyo Makin versus Attorney General and the Speaker of Parliament, when I sat as a judge, I failed to hear the side of the Speaker of Parliament before the Supreme Court made an order, so I should be removed as Chief Justice. Again, I can only point to the fact that no judge sits alone in the Supreme Court, and the court's decisions are the decisions of all the judges who sit together. So you will see that every decision I took that is complained about by Mr. Ofori, Mr. Akogo, and the group calling itself Shining Stars was done as a part of a panel of at least 5 judges that made up the Supreme Court. And all judges in the panel are indemnified by Article 1273. How tenable, if I can respectfully ask, can it be that a petition to remove the Chief Justice from office can be entertained on these grounds? I have also received threats and veiled threats to the effect that if I fail to resign or retire voluntarily, I will be made to suffer some harm or the other. I've also heard commentaries in the media about how this process was born out of a stated political agenda to remove me and control the judiciary, and that it is a political effort that can only result in an outcome that was decided long before it started. I thank everyone who has engaged in this conversation out of concern for my safety and well-being. Let me assure everybody that I am not seeking to cling to a title or a position. However, as a lawyer of 38 years standing, a judge of 21 years standing, and Chief Justice who has served the rule of law all my working life, in fact since I was 25, it is my onerous duty and obligation to speak up concerning anything that is extremely wrong with the administration of justice in this country. This is what I do every day. The situation I have been confronted with has shown me a model of injustice that I would never have thought possible if I had not been exposed to it. This is why, despite great personal discomfort, I have decided to marshal every effort in law and leadership to answer to this situation. Again, resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you fail to defend yourself. And a judge who resigns or retires will still lose all entitlements that they have worked for because they failed to defend the claims and resigned or retired while the proceedings were still going on. Therefore, if false claims are made against a judge or commissioner or other public office holder subject to Article 146 proceedings, just to achieve a political agenda, featured very prominently in the planning of the murder of judges on June 30th, 1981. And this can be read about in the special investigative report on that terrible event in our nation's history. It will be recalled that there was a Major Samakwa, a military officer who was killed with the 3 High Court justices, who was the director of human resource of GIHOC. He was my uncle and my guardian when I entered the University of Ghana in September 1980. I was also living with him at the time he was abducted and murdered. Was Edu Lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there's no reason why a judicial hearing is being conducted behind the high walls of Edu Lodge. At this Article 146 hearing, no rules provided by law to regulate the fairness of hearings and trials in this country are being followed. I started an action in the Supreme Court. I applied for the proceedings of the committee set up by His Excellency the President to be held in public, so that in the interest of transparency and for the truth in the matters being raised to be made known to the people of Ghana. I did so because I knew that the secrecy of the proceedings for removing justices was not created in the Constitution as a cover-up for any agenda. The Constitution expects that only reasons for removing the Chief Justice and public officials as set out in Article 146 will be the reason for doing so. And especially, such reasons must affect public sensitive national interests or public order or safety. I realize that in my case, should the public be made aware of the allegations in the petition, they would realize that none of the allegations made border even remotely on matters of national interest or matters of public order or anything that indicates that I'm unable to perform the functions of my office. An example is an allegation that I failed to retire accountable interest of $14,000 when I traveled. When I did retire that accountable interest 2 days after I returned from my journey, I was given $14,000. I could only spend $4,400, and I returned $9,600 2 days after I returned from Ghana, from my journey. And so I knew that it was necessary that the issues being thrown around as petitions against me needed to get into the public space.